And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brynteson, the managing attorney with the American law firm. This is a half-hour informational news call-in show devoted to a variety of legal topics of interest to State Line viewers. We have attorneys standing by right now to take your call at the number on your screen. They'll be able to provide you with free information regarding your legal issue. So call now and throughout the next hour. Our opening statement, we'll be discussing liens that an insurance company can place on a settlement, as well as jury selection in a personal injury trial. Let's remind you of the multiple practice areas in which the American law firm concentrates. The American law firm is a general practice law firm concentrating in divorce and family law cases, bankruptcy matters, personal injury claims, criminal, traffic, and DUI issues, wills, trust, and probate matters, real estate and business transactions, and immigration and naturalization services. So feel free to call now and discuss any of these areas with attorneys who are standing by. So Mark, welcome to the show. We have plenty to talk about tonight, I think.
Yes, sir.
Let's start with something very interesting.
Sounds puzzling.
It sounds puzzling a little bit, and it's a little complicated, so I want to read it to you just to make sure I understand it. Health insurance companies, if they're paying out for injuries received, can then actually put a lien on a victim's settlement proceeds. They do that often?
All the time. It depends on the state, but if state law allows them to, that's correct. I can compare and contrast Illinois and Virginia because I practiced in both states. Mm-hmm. In Virginia, when an injured person comes to me, I'll tell them, have your health insurance pay the bills, and then we'll settle up with the at-fault driver's insurance company later. And when you do, you don't have to pay your client's health insurance back. In Illinois, you have to, and it's all state law. Virginia state law doesn't allow that. Illinois state law does. And I believe the question has went up to the Supreme Court in each state, argued the same way. In Virginia, the justices, Supreme Court justices at the state court said, well, you're paying a premium for health insurance. They can't be paid back because then they're not fulfilling their contractual obligation. So they pay and then they get paid back, so the premium you paid for that treatment was no good.
Yeah, what's the point?
So what's the point? It's like a big Ponzi scheme, is what the court said, if they allow it. Well, in Illinois, they're allowed to do just that.
So the insurance company pays out. Once a settlement is done, they get their money back.
Back from the at-fault driver's insurance company, they get paid back.
Okay.
Called
That's an interesting thing, right?
Ponzi scheme.
Okay, all right. Well, lawyers are standing by to take your call, so remember to call 815-394-1776. So is this question, is this only tied to any not only settlement proceeds, but any other property that they may have? Well, or strictly on the amount of money that they get from the settlement?
Well, it's only from the settlement. And one of the things you can do is if a lawyer's involved and it's not a federally controlled health insurance program, you can negotiate down in most cases, if a lawyer's involved, the amount you have to pay back. So let's say you owe $10,000. If it's not covered by what's called ERISA, that's a federal law, if it's not covered by that, you usually can negotiate down what the insurance company will take. So in other words, if it's a $10,000 bill, you may be able to negotiate it down to $7,000 or $6,000. The difference between 10 and 7 or 10 and 6,000 goes in the client's pocket. And then the insurance company will get paid 6,000 or 7,000, but they still get paid, reimbursed for something that you paid them to pay out. Mm-hmm. And really not fair. Ponzi scheme. I'm sorry I come back to that because that's really what it is.
Two words.
Two words.
Ponzi scheme. That's what it is right there. Well, how soon would an insurance issue of this matter, how soon would that occur?
Well, when a client comes in and sees us, and this is really one of the risks of handling a personal injury claim on your own, you don't know all this. And one of the things that happens, we see routinely, is a client will come in and say, I've settled with my insurance company, they've signed the final release, and then they get a letter with the at-fault driver's insurance company, they get the money, and then they get a letter from their insurance company saying, hey, pay us back X amount of dollars. Now, if the attorney's not involved, they won't reduce the amount you pay them back. They want everything. And then you have to pay them back everything you thought you had in your pocket. That's why you need to get to an attorney right away, because you need to handle that from the beginning of the case, not the end. Because the at-fault driver's company is not going to tell you about it.
Okay. Always get some good advice.
Yes, sir.
All right. The number to call, by the way, 815-394-1776. We have more to discuss coming up. You're watching Legal Matters with the American Law Firm. We'll be right back. And welcome back, everyone. I'm your host, Alan Jones. With me is attorney Mark Brynteson with the American Law Firm. And you're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. Attorneys are standing by right now to take your call at the number on your screen, 815-394-1776. They'll be able to provide you with free information regarding your issue, so call now. Well, lawyers will be standing by for another half hour after the show ends. We've talked about a number of things today, Mark. This time we're going to kind of shift gears a little bit and talk about jury selection in a personal injury case. It may seem pretty simple to the layman. You pick a jury, it's as easy as that. But talk a little bit about the American Law Firm's experience and some personal experience. How do you go about doing that?
Well, one of the things that happens before the trial even starts is you have to pick a jury. And you are allowed, as attorneys for both sides, to ask questions of the potential jurors and find out if anybody has a bias. Such as there are some people that just don't want to give anybody any money. They don't think they deserve any money. You may get an insurance adjuster sitting on the jury. You don't want that. So you try to narrow it down to a jury that will give you a fair shot on both sides, and that's really what you want. I had a case one time. It was a medical malpractice case up in Newport News, Virginia. Jury, we finished trying the case. Jury came out and asked a question, and they went back in, and one of the gals said, well, we have to assume that it was a sulfonamide. That's a antibiotic. And we were all wondering, how did she know that? And I found out later she was a nurse, and she didn't disclose that when we asked the direct question, was anybody a healthcare provider? And so there's some honesty there too, but you want to know those things so that you don't get sandbagged in the trial.
Know as much about the people who are deciding things as you can.
Yes,
sure.
It's just so it can be a fair process. One of the other parts too is in personal injury cases, juries generally, after they've rendered a verdict, will come up and they'll talk to the attorney. They'll be waiting outside. They want to talk to him, and not always, but they will. And one of the things that's really astounded me over 25 to 30 years of practice is in a personal injury case, when you come out, the juries will routinely ask you, or jurors will ask you, did the defendant have any insurance coverage? Because that actually factored in. It's not supposed to, and there are jury instructions that say you're not supposed to take what effect this might have on the defendant into consideration. Most juries don't know that if you're at trial, the defendant is insured. That's how the defense attorney's there. The insurance company's paying for that defense attorney. Somebody that's working like at McDonald's or something, they can't afford to pay an attorney. Well, how do they get it? Their insurance company's paying for it. But many, many jurors get stuck on the amount they're going to award the plaintiff or the injured person because they think they may be penalizing the defendant. Well, they're not. You wouldn't be in court if there wasn't an insurance company behind the defendant and that defense attorney. So that's just one of the common myths that jurors sometimes factor in there, that you're not in the jury room. You don't know what they're discussing and the things that they may draw that have no bearing on the case, but are we going to hurt the defendant too much without regard to, well, you're going to leave the plaintiff with a lot of medical bills if you don't give an adequate verdict. And that's some of the things you're dealing with all the time as an attorney.
I was wondering, I mean, you don't really know what juries are thinking. You don't know how they perceive the evidence. You can only assume that they're doing their job. So I mean, it's good you have that give and take following you. That gives you a little bit of insight as to how juries and how jurors think.
And that's correct. And the people most people are very good people sitting on the jury. But sometimes you can bring a bias that affects the decision that shouldn't be affecting the decision, such as an insurance adjuster sitting in an automobile accident case and they adjust automobile accident cases. They're going to have a bias, just like me. I can give you my wife. My wife has been called to jury duty many times, and when they're doing the pre-juror questioning, they ask, what did your husband do? He's an attorney. Well, what kind of law does he practice? He's a trial lawyer. Well, what kind of trial lawyer is he? He's a personal injury trial lawyer. Oh, Judge, we'd moved to strike for cause, and they go off.
Yeah.
Not because she would probably be very fair, and probably towards the other side, because her dad owned a bunch of lumber companies and cement and hardware stores, so she's on that side of it. She'd probably be very conservative. But she's gone just because of what I do.
Well, what you do, yeah. Talk about a trial. Not every trial has a jury that makes that decision. Sometimes a judge. Is there a benefit either way?
It depends. It could be. If it's a complex case, it may be better to have a judge determine it. I can give you an example. I'm an arbiter for the Winnebago County Circuit Court. I hear cases in three arbiter panels. We're appointed by the court to hear and determine cases. Sometimes you like that because a little more sophistication and understanding, especially in a personal injury case, the injury helps get a better result. For instance, a lot of times a three-judge or a three-arbiter panel of attorneys will render a decision, and then the insurance company will reject it and still want a jury trial because they think the jury is going to do them a better service. Sure. That's why we really need to get away from unanimous juries. Like you have 12 people on a jury, you need to go from a 12 down to a majority. So 7 or 6 out of the majority will determine it instead of unanimous.
Okay. So is that a possibility or just something?
Well, a lot of states.
That'd be a great idea.
Some states are going to it, and it's being batted around. I think that would help out a lot.
Okay. All right, Mark. Thanks for that information. Great input.
You're welcome.
Once again, lawyers from the American Law Firm are standing by to take your call, no matter what the topic. The advice is free. 815-394-1776. Lawyers will be taking calls for a half hour after the airing of the show, and we'll be back with a closing statement when Legal Matters returns.